Good afternoon and welcome to our media briefing for December 17th, 2019. Today I want to simply set the record straight on a number of points related to Wayside Cross Ministry. First, let me clearly state that the City of Aurora in general and myself as mayor in particular acknowledge the work and longevity of Wayside Cross in Aurora for nearly a century. That has never been in question. I have personally referred people to that program. As an alderman, I supported the expansion of Wayside into its current facility, and pretty early on in my administration, I also visited and toured Wayside. The following year, we partnered with Wayside on a beautification project for downtown Aurora, and we continue to support their women's ministry by lending them a city-owned building for $1 a year, and we've done that for many years. I'm saying this to say there is no personal vendetta against Wayside on my part or the part of my administration, period. Last week, notices were given to 19 child sex offenders living at Wayside for the second time. So let me set the record straight. This process of notifying predatory sex offenders of their 500 feet violation actually began last year, right around this time, with notices of the city's intent delivered this past July. As we have stated before, but has been left out of so many subsequent stories, a process to properly give notice to our parks for public safety reasons also led to the discovery of faults in how we mapped our parks. We determined that McCarty Park, with its signature children's splash pad, was a playground and located within 500 feet of Wayside Cross Ministries. We also recognized that a number of child sex offenders were residing at Wayside. So let me set the record straight even further. The realization of so many child sex offenders at Wayside was a complete shock to all of us here at City Hall. For 90 years, Wayside has operated in Aurora and is well known for its ability to help people get a better handle on life. For many of those years, it was those who possibly faced alcoholism, drugs, or mental health issues. I don't know when or how child sex offenders were added to the list, but the city wasn't part of that discussion, not my administration, and based on conversation of those who worked for the previous mayor, Tom Weisner, not during his administration either. Now back to the timeline. In February 2019, my staff met with Mr. Lukos, director of Wayside, to inform him of our findings and to let him know that there could be a significant impact on his program because of the state law that prohibits child sex offenders from living within 500 feet of a playground, and the fact that we determined the error in our GIS system. During that initial meeting and subsequent meetings, my staff not only continued to keep Mr. Lukos updated, but specifically asked him not to continue to take in child sex offenders until a more thorough review could be conducted. We recognize that if the law prohibited child sex offenders from residing at Wayside, it made sense for Wayside to at least temporarily halt their admissions. Since that initial conversation, Wayside has admitted an additional 6 predatory child sex offenders. Clearly, he did not heed or even inform us of his decision to continue to taking in these predatory child sex offenders, although he clearly knew the impact on their lives. We met with him as a community partner, and he ignored the information we brought to him 12 months ago. Now fast forward to the end of March, when the city was blindsided with the residency at Wayside of convicted murderer Thomas Kokorales. Yes, we were blindsided by the very notion of the idea that a convicted serial killer was living in Aurora, but also at the decision of Mr. Lukos to ignore our strong working relationship, particularly working on the child sex offender issue. It is no secret of my opposition to Kokorales living at Wayside. But let me again set the record straight. The child sex offender issue predates Kokorales being in Aurora. And one issue has nothing to do with the other than the fact that Wayside Cross is the common denominator. After reviewing the issue, Aurora Police gave notice to 19 registered child sex offenders on July 5th, informing them of the need to relocate to a location not within 500 feet of a playground. Let's be clear. Let's be very clear. This is a state law. This is not a city ordinance or some whim of the administration. This is a state law put into place for the protection of innocent children. Aurora didn't initiate it, but the Aurora Police Department is obligated to uphold the law by monitoring child sex offenders and confirming the legality of their residence every time a child sex offender is required to register. This is about a playground and proximity, and the law that has been implemented to protect the children who use those parks and playgrounds. While we are on this topic, let me set the record straight yet again. Aurora didn't suddenly just make McCarty Park a family destination in light of this particular situation. McCarty Park was renovated a decade ago. The splash pad was implemented as a key feature of the park to attract families and children to the neighborhood park. In fact, the splash pad predates every child sex offender residing at Wayside at least 5 years. For years, every single summer, thousands of children play on the splash pad, and community events are regularly held there that attract children, from free lunch programs to back to school celebrations hosted by the local alderman in that ward. The Kane County State's Attorney has deemed McCarty Park a playground as defined by the state statute that prohibits registered child sex offenders from living within 500 feet of it. Now, those notices were served nearly half a year ago in July. A pending federal lawsuit put all actions on hold until further review. A lawsuit filed by the residents at Wayside in question. That was not an Aurora decision. As we all know, that lawsuit was dismissed by the plaintiff's motion. To be very clear, the City of Aurora did not dismiss the lawsuit. It was voluntarily dismissed by the very attorneys of the clients who live at Wayside. I'm an attorney by trade and have been practicing for more than 20 years. You voluntarily dismiss a case, not for the general principle of the matter, but because you believe you don't have strong legs to stand on, or you need to rethink your strategy. After the dismissal, we consulted the Kane County State's Attorney, and after conferring with his office, issued new notices last week. Those notices directed that non-compliant residents should move by January 15th. After that time, we will inform the state's attorney, who will conduct his own investigation before taking actions should those predatory child sex offenders still remain at that location. Some have said, why would this have happened right before the holidays, in the middle of the winter? That the mean Scrooge mayor just had a personal bone to pick with Wayside. Again, let me set the record straight. Notices were given back in July, in the summer, not the winter before the holidays. The lawsuit, which was subsequently dismissed, brought a decision of an action for months. Now we're here. So let me make this plainly clear with 6 points. Number one, the state's attorney believes that McCarty Park is a playground. It's not just the city, it's the Kane County State's Attorney. The state's attorney believes, number two, the state's attorney believes that persons who reside at Wayside Cross are residing within 500 feet of McCarty Park. Number three, the city does not have the authority to register child sex offenders who wish to reside at Wayside Cross now that the federal case has been dismissed. Number four, consistent with past practices, Aurora Police Department has notified child sex offenders at Wayside that they must move by January 15th, 2020. Number 5, if child sex offenders continue to reside there after January 15, 2020, the Aurora Police Department will notify the state's attorney, who will review the allegations and make a charging decision. Number 6, regardless of anyone's feelings about the residency restrictions, the Aurora Police Department can't look the other way with respect to what Illinois law deems to be a felony offense. We can't look the other way. It's the law. Questions?
How could you be shocked there are sex offenders there when these sex offenders actually have to go to the Aurora police station and register?
As we stated, the mayor's office and administration were not aware that these 19 sex offenders were at that location until we started attempting to give our parks new addresses and reached out to Wayside administration and told them that they were within 500 feet of a park, and should they have any child sex offenders there, or offenders that weren't that could not live within 500 feet of a park, they'd be required to move. At that particular time is when we determined that they were within 500 feet of the park. Question?
But again, how could you, if they have to go to the city of, they have to go to the police department in Aurora to register that they're sex offenders. This place has been here for decades. You supported an expansion of the building, and how? So I don't understand how the city was not aware that there weren't sex offenders at that place.
Let me explain to you. Well, as pointed out, our GIS system at this particular time identified that particular park in the center of the park and not from property line to property line. So once we looked into giving all these parks addresses and indicated their property line at the edge and not the center of the park, that's when it was determined it was within 500 feet of that location. Question?
Can you address the concerns of the residents who fear that evicting the 19 sex offenders from a program like Wayside Cross would disperse them into the communities further and they'd be less monitored?
You know, the fact that you asked that question and that there'd be a concern that these men, these predatory child sex offenders who have been found guilty and now are required to register, the fact that you asked that question suggests that it's possible that these men could may be dangerous and should not be within 500 feet of where children play. So wherever they live, it cannot be within 500 feet of a playground.
Doesn't Wayside Cross kind of monitor where they are and
It's not up to me to determine the Wayside Cross's ability, or the police department to determine whether or not Wayside Cross has the ability to monitor or not monitor. What our job is to do is follow the law. And the law says that no child sex offender can live within 500 feet of where children play at a playground. Other questions? Yes, sir.
What date was the lawsuit dismissed, and how soon did you start reconsideration of
You know, I'll have my legal counsel, Rick Vinscher, step up and answer that question.
The lawsuit was dismissed just before Thanksgiving. Excuse me, just before Halloween.
date?
So-
Approximately October 27th or thereabouts. I can give you the exact date.
Okay.
Some of these men are concerned that, because they are registered sex offenders, it's going to be pretty difficult for them to find a new place to live and a job or anything. I mean, again, don't you think that they may be safer where they are than being out on the street homeless?
You know,
I mean, if we're
it's funny to
talking-
me that most people ask questions about these convicted child molesters, and I rarely get questions about the victims in those particular cases. Would you ask the victim in that case that this person should be able to live within 500 feet of where they play just because there's a location where that could house them? Wherever these men live, these convicted child sex offenders, predatory. And the reason this law was created by the state was to protect those innocent children who cannot speak for themselves. And they said, these men, these convicted child molesters can't live within 500 feet of a playground. They can't live within 500 feet of a daycare. So I think that's the question we should be asking. What about the victims in these cases? Next question.
Just a follow-up from my earlier one. When did you start, again, reconsidering your actions following the dismissal? Was it within a week or? 10 days?
Very shortly after the dismissal of the case, we again reached out to the Kane County State's Attorney to basically discuss with them what their view of the nature of McCarty Park was and how to calculate the distance. And after some conversations, they did confirm that it was 500 feet measured property line to property line, and that based on the features of the park, it did constitute a playground.
But that was determined months ago. I'm talking about the current action of issuing the
Yeah,
order for.
Our final
them to-
conversations with the State's Attorney were last week.
Okay.
And it's January 15th, not 30th, right?
January 15th, yes.
Okay.
Questions from the media?
May I
Yes, sir.
Ask either of you that are sitting up there right now. Aurora has home rule and in many cases is able to do things on its own that I guess you'd say supersede state law. Why can't they do that in this case?
This is not one of those cases that you can supersede state law. And I don't know that this is one of those cases where we want to attempt to. This isn't a traffic offense where somebody was driving 5 miles over the speed limit and maybe a police officer decided to let him off. Or a situation where maybe a police officer stopped someone that possessed cannabis, the fact that it's going to be legal in a month or so, and maybe not charge them with a crime. This is a circumstance where the men that we're talking about have been convicted of molesting children and possessing pornography, where children are the victim. Child pornography, children are the victim of these pictures they possess. This isn't one of those where we can just look the other way. Question. Any other questions from the, yes, sir?
As you well know, the attorneys for the sex offenders have said two things. One they've said is that the playground isn't within 500 feet of the park, and that the playground essentially consists of hobby horses that were put there to give you the grounds to evict these residents.
Well, that was what they stated in the filings when they filed this federal lawsuit. However, they dismissed their lawsuit because they recognized that it had no legs. As I stated, the splash pad was put there 10 years ago, which made this a playground. Children play there all summer, almost every day. And that playground predates any of those predatory sex offenders filing as residents of up to 5 years as residents of Wayside Cross Ministry. Next question.
And kind of a follow to the earlier question about having residents maybe in one location where you know where they always are, and it's easier to track them than perhaps having them scattered throughout the community. Where people ask if maybe one is better than the other, your response to that?
My response to that is the law states that no child sex offender, predatory child sex offender, can live within 500 feet of a playground. There's a playground 500 feet away from Wayside, property line to property line. Therefore, based on the law that we must follow, they cannot reside at Wayside Cross Ministry. And I expect that's probably a question you might want to ask Wayside, as where they're going to make sure they relocate these individuals so they can provide the services they need, as long as it's not within 500 feet of a playground or a daycare. And I don't accept that their answer being the big and long-standing organization that they are, that they don't have a clue. Next question. All right, well, thank you very much. This concludes our media briefing for today.